With due respect, my lord, I like to mention one case, my lord. Everyone yesterday argued the matter. Item number 17 today, it has been listed. So may I pray for the matter may be updated and may be taken as item number 1. I will finish it within 10 minutes, my lord. I have to kindly consider it, my lord. Supplementary list item 70 has listed before your lordship.
Is subject to what the other council says.
Aside, I have taken consent.
No, I have not
That is
given
not your
consent. I have
There
not
are
given any
other matters,
consent.
well ahead of you.
No, my lord, well, it will
Don't
take
make it
short
your
time, my lord,
observation.
because part already matters.
Consent of the other parties. Item 1.
Oh, oblige.
Malot, I व्यक्ति macam item number 9 ya man.
Yes.
9 malot, kindly adjourn the matter for 2 weeks, malot.
Mention slip is there.
Malot, I am sorry, malot, I could not give him them.
Every day you are making a mention without
My
any
lord.
mention slips. Every day you are saying sorry.
As instructed by senior malot. Only adjourn the matter for 2 weeks, malot.
I asked him yesterday afternoon and then they said that they'll be taking adjournment. That's all.
That's meant by RR. The council for that. This the matter after 3 weeks.
I remember.
May I please, lordship, I beg to mention item 15, lordship. May I pray for 2 weeks?
Same, no mention. They have problem.
They have not informed us, informed
How do you
us
do
now.
this when there's already a notification to that effect?
They have informed us in the morning in the court hours after reaching court, but
You are Mr.
That is Roman.
Raman, then the council for that. This couple 3 weeks.
Oblige, lordship.
May I please, your lordship? I beg to mention item 13, kindly possible for the day, and if it is possible, kindly fixed on next week on 23 or 24.
So appearing on behalf of
AK Purogayastha. I have taken consent of the other parties.
appellant council is present.
I have taken
it's an
consent.
appeal against acquittal. As far as I'm concerned, I'm not informed, but perhaps
I'm on behalf of P. Bhattacharya, your lordship.
same party.
Next week, if it is possible, 23 or 24.
On the first, whether we have a PK prepare still the council. Respondent number,
One.
not be one.
Respondent number 1 is me,
One. maybe.
state.
One.
For the
Perhaps you are
private
2.
For the private respondent, one or two. Please get back after 1. I can't give you date.
Right.
Yes.
Published.
May it please my lordship. My lordship, I beg to mention item number 5 and 6, my lordship, of the hearing column.
Yes.
My lordship, we are going to file an IA for suspension of the sentence, my lordship. My lord, in this case,
Have you
accused,
informed the other side?
yes, my lordship.
When?
Today they are here only. She's here.
Where's your mention slip?
My lordship, I'm so sorry, I didn't place the mention slip before you, lordship.
Every day.
My lordship.
Your MS,
MSN, my lordship.
name,
MSN, my name is not reflected in the course list, my lordship.
you are appearing on behalf of?
SK Nargis, my lordship.
On request made on behalf of SK Nargis, let me council for that. This the matter after 2 weeks.
My lordship obliges.
Item 1, 2, and 3, admission.
Lordship, with due respect to my senior counsel for the petitioner, actually, my lord, my matter is IA, I filed that matter. It's very simple, my prayer is also very simple. One student who was allotted by this order on 6/1/2023, she refused. And the learned counsel, advocate counsel for the petition also admitted that she took seat in another state. So one seat is remained vacant. So the applicant is the eligible one. So So my lord, it may kindly be considered before the main argument. My lord, actually, since I just passed out advocate on record at Supreme Court, my induction is going to be at forenoon on virtual. I have to attend also around 12. This IA.
Basically, that's the reason why you want to take up this IA first, isn't it?
Yes, my lord.
My lord, this IA cannot is not maintainable. Let him file his own writ petition, my lord. In my IA, he cannot seek any relief. My learned friend should know that. As an OP, you cannot seek relief in somebody else's petition. If you have any independent cause of action, file a writ petition, get whatever order you
Take
like.
up this matter
Yes,
together with
yes,
the writ.
yes.
Yes.
My lord, I think this matter is already delayed, my lord. I'll respectfully submit, possible to go ahead with the hearing, my lord.
My lord, the order itself speaks clearly that that interim order is subject to further orders of this court.
My lord will kindly take the PIL, my lord. PIL number 6 of 2021. Book list this, huh? This- Yes, at least it would be. 6 of 21, my lord.
6.
Yes.
44, 44.
Or renumbered as PL 44 of 22. My lord will kindly come to page number 45. This is the amendment which you have challenged. Mm. 31st of May 2021. Pursuant to the decision of the Council of Ministers, which was obtained by means of circulation and conveyed by Political and Cabinet Department, white dated 25/5/21, and in the interest of public service, Governor of Mizoram is pleased to make the following rules further to amend the Mizoram selection of candidates for higher technical courses rules 2016 as follows. My lord will kindly come to amendment of Rule 5, with which we are concerned. In Rule 5 of the Mizoram selection of candidate for higher technical courses Rule 2016, Sub-Rule 1 shall be substituted by the following. All applicants shall be classified as follows for the purpose of allotment of seats. A. Open category. B. Children of local permanent scheduled tribe ST Mizoram, residents of the state of Mizoram as category 1. Children of other local permanent scheduled tribe ST non-Mizo resident of the state of Mizoram as category 2. Children of other non-scheduled tribe non-ST permanent resident of the state of Mizoram, and children of parents who are serving under the government of Mizoram, autonomous bodies, etc. as category 3. Children of state and other state government employees not permanently staying in the state of Mizoram as category 4. So these are the 5 categories, my lord, in which, my lord, the students have been categorized. Then my lord will kindly come to the next page. Explanation. For the purpose of this sub-rule, the term open category shall include candidates belonging to any of the scheduled tribes of the Mizoram who have been permanently residing in the state of Mizoram, provided that to be eligible for consideration under open category, the candidates should have passed class 11 and 12 from any of the schools within Mizoram state recognized by the government of Mizoram. That means, my lord, if somebody wants to claim any, admission to any educational institution of higher technical courses, my lord, the open category which shall include any of the scheduled tribe, including everybody, my lord. But there is one rider. The rider is the candidates should have passed class 11 and 12 from any of the schools within the Mizoram state as recognized by the government of Mizoram. The term Mizo shall mean those who are geo-ethnic indigenous people of the state of Mizoram and have been residing permanently in this state, and term non-Mizo shall mean non-geo-ethnic scheduled tribe people of the state of Mizoram and have been residing permanently in the state. So, my lord, the Mizo and a distinction is sought to be made within the class of scheduled tribe between Mizo, that is Geo-ethnic, and non-Mizos. 2. Subrule 2 shall be substituted following, namely, percentage of seat allocation shall be 4% for open category, 93% for category 1, 1% for category 2, 1% for category 3, and 1% for category 4. If 1% is less than 1, then in such case it will be rounded up as 1 seat. Provided that to be eligible for consideration under category 2 and 3, the candidates should have passed 11 and 12 from any of the schools within Mizoram state recognized by the government of Mizoram. Provided further that to be eligible for consideration under category 4, either of the parents, wherever is serving, should have been posted in Mizoram continuously at least for the last 3 years, and the candidates should have passed 11 and 12 from any school within the Mizoram state recognized by the government of Mizoram. My lord, this is the rule which is under challenge. Now, my lord, to put it very simply, first, by this rule, a sub-classification is sought to be made regarding the scheduled tribes of the state of Mizoram. Therefore, the first question which will arise is whether it is permissible or not. The law as it stands today, my lord, it does not permit. For the state of Mizoram, for example, if a lordship will kindly come to, my lord, the scheduled caste list, and just show it, my lord. Yes, page 87. Page 87, my lord. Towards the bottom part, Roman 17, Mizoram. This is the, my lord, 1950 scheduled tribe order under the constitution. Sakma, for whom we are representing, my lord, this is the first one. Dimasa, Garo, Hazong, Mar, Khasi Jaintia, any Kuki tribe, including so-and-so, so-and-so, so-and-so. Then my lord will kindly come over to the next page. So many, people are there, my lord. Serial number 10 is any Mizo, Lusai tribe. Serial number 10. So therefore, in terms of Article 342 of the Constitution of India, my lord, the power vests with the president. The power never vests with the state government. It is the prerogative of the union, my lord. Yes. Oh. Constitution Pandya, sir. My lord, may kindly have a look at Article 342, my lord. The president may, after consulting the governor, specify the tribe or tribes to be ST in relation to the state. Now, my lord, then the second aspect is regarding, my lord, prescription that, my lord, the candidates must study class 11 and 12 in the state of Mizoram. Interestingly, my lord, while prescribing that, it has not been prescribed in respect of Mizo. Kindly see once again, my lord. Please come to 46, my lord. First, my lord will kindly come to page 45. 45, my lord, rule 5B. Children of local permanent scheduled tribe Mizo residents of the state of Mizoram as category 1. Am I clear, my lord? Then, my lord, others are non-Misos are category 2, children of non-STs are 3, central government and state government employees 4. Now, please come to my lord, next page. 46. The term open on top, the term open category shall include candidates belonging to any of the scheduled tribe of Mizoram who have been permanently residing in the state of Mizoram, provided that to be eligible for consideration under open category, the candidates should have passed 11 and 12 from any school within the state of Mizoram. So in respect of open category, it is prescribed. Then my lord will kindly come to rule 2. Rule 2 proviso, which has been now inserted. Provided that to be eligible for consideration under category 2 and 3, the candidates should have passed class 11 and 12 from any school within the Mizoram state. Now, in respect of category 1, this prescription is not there. So that is the discrimination. Well, in Assam, this particular clause was challenged, but the Honorable Court has upheld because it was uniformly applicable to all. Unlike in the state of Mizoram, where my lord, requirement of studying in the state of Mizoram in class 11 and 12 has not been prescribed for category 1 candidates. That is the dominant Mizo community. So therefore, my lord, it can't be. Now, my lord, lordship need not take any trouble, my lord. The exact same rule was put to challenge and it has been interfered by this Honorable Court. My lord will kindly come to page 60. The judgment of the division bench starts at page 60. I'll have your lordship's kind attention to page 64. The rule before its amendment, my lord, it stood like this. Please come to page 64, 2016 rule. 5. All applicants shall be classified into 3 categories for the purpose of allotment of seats. Children of permanent resident of the state of Mizoram as category 1. Children of other permanent resident of state of Mizoram, that is category 2. Children of central or state government employees not permanently residing in the state of Mizoram, category 3. Earlier, the rule, the predecessor rule, my lord, was this. Explanation. The term permanent resident means those who are geo-ethnic people of the state of Mizoram have been residing permanently in the state. The term other permanent resident means those who are children of non-geo-ethnic people of the state of Mizoram and have been residing permanently in the state. Children of parents who are serving under government of Mizoram, corporation or autonomous bodies under the state. Government who are regular employees of such organization and in whose case it can safely be inferred that they would reside permanently in the Mizoram, including the children of deceased employees of the state government whose families have been residing in the Mizoram. And lordship may kindly skip over to the next page. To be eligible to be considered under category 3, either of the parents of the candidates should have been residing and posted in the Mizoram for the last 3 years. We're not concerned. 2 is important. Percentage of seats for category 1, 2, and 3, 95% of the total seat shall be reserved for category 1, that is, my lord, geo-ethnic tribe. 4% of the total seats shall be reserved for category 2, and 1% of the total seats shall be reserved for category 3. That means 95% is for people of Mizoram and 5% for others. Now, my lord, this rule was put to challenge. Now, let us see, my lord, how this was dealt with by this Honorable Court. My lord will kindly come to page 69, para 16. In Milin, that is, my lord, 2001, 1 SCC page 4, the Honorable Supreme Court had observed that the Parliament alone is competent by law to include in or exclude from the list of the scheduled caste and scheduled tribe specified in the notification issued under clause 1 of the said article. Whether a particular caste or a tribe is a scheduled caste or a tribe, as the case may be, within the meaning of the entries contained in the presidential order issued under clause 1 of Article 341 and 342 is to be determined looking to them as they are. In E.V. Chinaya, that is my lord 2005 1 SCC 384, the Honorable Supreme Court held that scheduled caste list prepared by the President under 344(1), in our case it will be 342, forms one class of homogeneous group for the purpose of the Constitution, and therefore subclassification or micro-classification of scheduled caste or scheduled tribe would violate Article 14 of the Constitution of India. So in these two decisions, my lord, Supreme Court has taken this view. The question that has arisen for consideration is whether, for the purpose of allotment of seats, categorization as contemplated in category 1 and 2 could have been legally made. The facts in Chennai were that State of Andhra Pradesh had appointed a commission to identify the groups among scheduled caste found in the list prepared by the President under Article 341 of the Constitution, who had failed to secure the benefit of reservation provided for the scheduled caste in the state in the matter of admission to professional colleges and appointment to the services in the state. Accepting the report of the commission, the state by an ordinance divided 57 castes enumerated in the presidential list into 4 different groups, namely A, B, C, D, based on their inter-se backwardness, and fixed separate quota for reservation for each of these groups. Accordingly, 15% reservation of scheduled caste in the state of Andhra Pradesh for admission to higher education institution and in services of the state under Article 15(4) and 16(4) of Constitution of India was apportioned among the groups, namely A, B, C, and D, by allotting so and so person respectively. In the aforesaid factual matrix, the Honorable Supreme Court held that Constitution intended all castes, including subcastes, races, and tribes mentioned in the presidential list to be member of the one group for the purpose of the Constitution, and this group could not be subdivided for any purpose. Argument advanced that to fulfill the constitutional obligation to provide opportunity to weaker castes, it is permissible to make classification within the classes was repelled by the Supreme Court. As a sequitur thereof, it was also held that subclassification or micro-classification of the scheduled caste or scheduled tribes would violate Article 14 of the Constitution. It was also held that if benefit of reservation are not percolating to members of scheduled castes equitably, measures should be taken to see that they're given adequate training so as to enable them to compete with others, but that would not justify to make further classification by a micro-classification. It was further held that a uniform yardstick must be adopted for giving benefit to the members of the scheduled caste for the purpose of the Constitution, and accordingly the impugn legislation was struck down as ultra vires the Constitution. So the Andhra Pradesh government, the ordinance which was issued, my lord, which was struck down by the Supreme Court. The Honorable Supreme Court said, if the benefit of reservation is not percolating to a particular section within that class, impart them adequate training, make them, try to make them at par with the others so that the benefit of reservation as provided under 341 to scheduled caste percolates to even to the weakest among the weaker sections. Now, para 18, my lord. In the instant case, categorization under Rule 5(1) of the 2016 rules professes to be on the basis of permanent residency. But permanent residents have been subdivided into 2 groups, namely permanent residents and other permanent resident. Permanent resident means only those who are Geo-ethnic people of the state of Mizoram, or in other words, people belonging to Mizo tribe. The other permanent residents mean those who are non-Geo-ethnic people. Categorization outwardly does not reflect that any attempt is made to make classification within the listed scheduled tribes mentioned in the principal SIP. However, there is no gainsaying the fact that Mizos and Sakmas are scheduled tribe under the Constitution Scheduled Tribe Order 1950. The objective of classification under Rule 5 is stated to be to reserve percentage of seats for the purpose of admission in higher education institution. If that be the objective, the scheduled tribes who figure in the Constitution Scheduled Tribe Order and who are permanent residents of the state of Mizoram could not have been placed in two different categories of permanent residents. Any attempt to differentiate the members of the scheduled tribe who figure in the presidential list under the Constitution Scheduled Tribe Order 1950 by any parameter such as permanent residency, etc., would amount to fiddling and tinkering with the presidential list, which is not permissible in law. Benefit of reservation has to be uniformly applied to all scheduled tribes listed under the Constitution Scheduled Tribe Order 1950. And it cannot be countenanced that one tribe would get higher percent of the reservation and another lower. In that backdrop, the basis of categorization, whether it was on the basis of performance in the STEE for the last 5 years or on the basis of appearance of students in STE in the last 5 years, carries no significance. Moreover, under Rule 5.1 of the 2016 rules, Chakmas and others are non-geo-ethnic children are made to compete with children of regular employees of the government who may belong to general category. That itself cuts at the root of the professed stand of the government that geo-ethnic people were placed in category 2, non-geo-ethnic people are placed in category 2 in order to subserve their interests. One swallow does not make the summer. The case of Niba Chakma has to be seen in that light. If non-geo-ethnic permanent residents are suffering from greater disability, opportunities should be created for their upliftment and development. The very idea that non-geo-ethnic permanent residents would vie only for 4% of the seats along with the regular employees of the government, while more advanced geo-ethnic community will have the benefit of 95% seat, is a step backward and which will over a period of time further widen the gulf between these two groups and push down the non-geo-ethnic people in the social ladder. It's a very scathing remarks, my lord. In view of the above, we are of the opinion that the impugned rule placing non-geo-ethnic people of the state of Mizoram in category 2 cannot be sustained. It is further observed that they have to be placed along with geo people of the state of Mizoram. Correspondingly, liberty is granted to the state of Mizoram to refix the percentage of seats to be reserved for the categories of the candidates as mentioned in Rule 5. Having regard to the fact that more than 2 years had elapsed, we do not consider it appropriate to interfere with the admission taken under the impugned rule. Now, in spite of this judgment, my lord, now the new rule has been brought into force, which I have already read. They retain the same thing. My lord, first come first, it is the prerogative of the central government to the President of India to declare who is a scheduled tribe. State has no power, my lord. At least under the constitutional scheme, state has no power. Now, before I make my other submission, the other day, my friend Mr. Das, appearing for the state of Mizoram, made a submission. Where is the judgment? Made a submission, my lord, that these two judgments, which was relied upon by the learned division bench of this honorable court, in a Punjab matter has been referred to a larger bench. Therefore, indirectly, what my learned friend was trying to submit is, we should await what the Supreme Court decides. But that is not the correct legal position. Honorable Supreme Court has said, if there is a reference, then the law which is holding the fill on the date, that will be applicable. On that, I'll just rely on one small judgment, my lord. 2012, 11 SCC 321. It এখন আছে না? 2012, 11 SCC 321. My lord will kindly come to para 23. para 23. Similar argument as has been made by my learned friend was advanced. Para 23, my lord, at page number 327.
There's no para 23 here.
2012-11 SCC 321.
Yes. Ashok,
Yes, Ashok Sadarangai. Yes. Paragraph 23, my lord, this
how does it start?
the learned additional solicitor general contended that
Para 16.
এখানে কি দিছে আপনি এসসিসি নাকি
This is legal.
oh maybe some other well it happens my lord different journals I do not know how different paragraphs my lord may kindly have that paragraph. Learned additional solicitor general contended that having regard to the divergent views expressed by different benches of this court, when the same issue surfaced in Gyan Singh, wherein the decisions in B.H. Joshi, Nikhil Marchand, Manoj Sharma came to be considered, the bench comprised of 2 judges was of the view that the said decision required reconsideration and directed that the matter be placed before a larger bench to consider the correctness of the said decision. Mr. Jain urged that as the same issue which was involved in the present case was also subject matter of reference to a larger bench, this court should abstain from pronouncing judgment on the issue, which was the subject matter in the said reference. So that is the argument here also, my lord. Now, my lord will kindly come to paragraph 29. The sentence starting with as indicated in Harbhajan Singh's case. As was indicated in Harbhajan Singh case, the pendency of a reference to a larger bench does not mean that all other proceedings involving the same issue would remain stayed till a decision was rendered in the reference. The reference made in Gyan Singh's case need not therefore detain us. Till such time, the decisions cited at the bar are not modified or altered in any way, they continue to hold the field. Therefore, my lord, a reference made in a particular bench is of no avail. So the Honorable Supreme Court says the law which is holding the field today, notwithstanding the fact that it may be a subject matter of reference, will continue to govern the rights and obligations of the parties. Therefore, my lord, my short submission in this case is this writ petition, this PIL has been filed by Mizoram Sakma Students Union. It was filed in the year 2021 because, my lord, we were sought to be denied admission into medical courses based on this particular rule. Though there was an interim order of this honorable court, my lord, we are never admitted. This contempt proceeding is also there. So 21 gone. Even in this season, my lord, only the other day, because of several interventions by this honorable court, one girl, Chakma girl, has been admitted. So that is that. Now, my lord, not only in medical, there's so many other courses, technical courses are there, where all applications, where admissions will be governed by these particular rules. Therefore, my submission is, my lord, prima facie, not prima facie, my lord, out and out, this rule is discriminatory. The same rule has been held to be discriminatory by this honorable court. Now, in spite of the pronouncement of the judgment, again, my lord, the rule has been amended, incorporating ad verbatim the same provision. So therefore, in my humble submission, my lord, this rule should be struck down and they should be directed, my lord, to forthwith, my lord, come up with a rule which is consistent with Article 14. Otherwise, my lord, it doesn't behove well on the part of a government, my lord, when a constitutional court has declared a particular rule to be bad in law and to reiterate that. I can appreciate, my lord, if a validating legislation is brought in, where, my lord, the basis of the judgment is taken away and a new rule is, my lord, incorporated, taking note of the basic judgment, then that is called validating legislation. That is not the case here. It's, my lord, trying to overreach the judicial authority of this honorable court. And this obstinacy is not good, my lord. End of the day, rule of law has to prevail. Otherwise, my lord, there will be chaos in the society. Kindly see, my lord, where do we go other than to coming to the constitutional courts? So here is a case, my lord. First, they cannot make further classification. Whole of the, scheduled tribe for the state of Mizoram, they have equal right. Now what they have done, my lord, they have given 94% to the, my lord, Mijos, and to non-Mijos, they have given only 1%. 1%. So this is not done. And I think I don't think had it been a case where in the earlier round of litigation, this judgment would not have been there. I may have to, took your lordship's more time to convince our viewpoint. Now it is already settled. What do I argue, my lord? I have just to point out the facts. Therefore, my humble submission is, my lord, I reserve my right of reply subject to what my learned friend on the other side says. It's an open and shut case, my lord. Lordship will interfere with the impugned rules and direct them to do the admissions of the all technical courses by following a norm, because they'll have to frame a rule afresh. Some rational norms, so that, my lord, everybody get a fair chance. I can appreciate, my lord, you can have some, for example, my lord, in medical admission, Supreme Court has recognized some percentage for the state quota seat, 15% for all India quota seat, something like that. Because, my lord, now the only problem which will come in the way of the state of Mizoram is, first, we all know the concept of protective discrimination as a proposition which was, my lord, propounded by Honorable Justice, my lord, Krishna Iyer in that medical admission case. Now, these are why it is called protective discrimination, because, my lord, when there is an ex facie deviation from the equality rule, then, my lord, it is called protective discrimination. Why it is called? The idea is to uplift somebody to a particular level so that one can compete. Now, in the medical admission cases, what was done, my lord? For example, in the Assam rule also, 85% is for the state of Assam, as in all over country. This legislation is permissible based on empirical data. Now, if in the state of Mizoram, we take the empirical data, Mizoram is one of the states in the country where the literacy is the highest in the country. So there will be a problem. They can't say Mizo people are backward. Today, if we look at the All India services, my lord, many Mizoram people are doing their services. In fact, they are very well off. On the contrary, look at this plight of the Chakmas. Where they are, my lord. On the contrary, my lord, there is a requirement on the part of the Mizoram state to come up with something for the Chakmas and other tribes who are, at the lowest end. Not the vice versa. Vice versa is not permissible because you are already developed. So you can't make any protective discrimination based on empirical data. If you take note of data, it will be otherwise. That's why it is said, my lord, when state makes a protective discrimination, then the burden is upon the state to prove why it has done. It is not on the citizen. So therefore, my lord, having regard to all these aspects, since the division bench judgment has already dealt with the issue, pronounced the judgment, and which has been Supreme Court. My lord, against the division bench judgment, the matter went to Supreme Court also, my lord. Oh, I'm sorry, my lord, I must have. Please come to page number 73, my lord. Page number 73. State of Mizoram, in fact, my lord, preferred an SLP. Special leave petition is dismissed as a sequel to the above. Pending interlocutory applications, if any, stand disposed of. Then, my lord, a review application was filed by the state in this Honorable Supreme Court at page 74. That was also dismissed. So, my lord, the order of the division bench of this Honorable Court has attained finally. So, there is no gainsaying now, my lord, on the part of the state that the reference is pending. Therefore, my lord, we should have it. That plea also is not available now in view of the clear position, made clear by the Supreme Court of India. So in that view of the matter, my lordship will allow this writ petition, strike down the rule. And in the interregnum, my lord, my humble submission is all these admissions should be done in a very transparent and rational manner, my lord, taking some yardstick which is non-discriminatory. That's my humble submission. Otherwise, my lord, I'll be repeating the same thing. I need not take your lordship's valuable time, my lord.
What about the other writ petitions?
My lord, oh yes. My lord, in fact, 285 is by a particular candidate. A2 is a content. 285 is by a particular candidate, same issue, my lord. I adopt the same argument as I have done in PI 44 of 20.
So if whatever judgment comes in PI.
That will cover the other cases. And there is one contempt petition, my lord, where, my lord, in the earlier round of litigation, when there was an order for giving admission, which was not given, no? In respect of 2 students. So for that contempt, anyway, my lord, now those have become academic. Of course, my lord, contempt is there, but I'm pressing the contempt, not really. No, we're not pressing the contempt, my lord. Lordship will decide the case on that. Because I cannot get back my admission. Even if they go to jail, I'll not get the admission. But they should not have done that. When there is an order of the court, either they should have tried to vacate the order, or in any case, my lord, they have gone to Supreme Court, they filed review, it was dismissed. So 285, same, my lord. I adopt my argument as in PL 44 of 22. In fact, my lord, this petitioner, Monita Dewan Chakma, she has been admitted this year, my lord. But the other one, there was another candidate, she did not get. She would have got, in fact, but my lord, because the state was delaying, she took admission in some private college, no? As a case.
This year. Admission was done this year.
Yes, Monita Dewan Chakma, she has been admitted in the current year, my lord. That too, after my lord, many. Earlier, my lord, when in 2021, she should have got, she was not given, she again appeared in the current examination, she again got, secured more than 300 marks. Then, my lord, she has been given admission. Only girl she has been given. Because the other one, the petitioner number 2 in 285, she could have got it, but my lord, because of the delaying by the state, she had taken admission in some other college. Effectively on merit, my lord, same issues. The validity of the rules. Number 1, just to sum up, my lord, whether they could have made further classification, and 2, whether they could have fixed the quota as has been done. Because the Honorable Court said that within that tribe, you cannot make further classification, therefore you cannot make the quota also. The division bench operative portion is very clear, my lord. We are paying the same relief. That's my humble submission. Lordship's kind permission, my lord. Can I?
May it please your lordship. My lord, we don't have to go through the Rule 5, which my learned friend already has pointed out before this court, which we made in 2021. The entire is a very narrow campus. Whether there can be any classification or not in view of the presidential order of 1950. That's what the case is about. If we can't make, that's the end of the matter. That's the end of the matter. You don't have to go to the other part which we said class 11, 12, because first your lordship has to look into the classification, which the state has made this classification. Because my learned friend, your recalls, I will not go through these papers, my lord. I'll just point out. 2016, we made the rules. My learned friend read the rules of 2016, which was put to challenge before division bench in PI. And my learned friend has read certain few paragraphs stating that the learned division bench relied on the judgment of the Supreme Court of 2005, E.V. Channaya's case, that there cannot be a classification which you are making. So the state has made a rule which is classified. There cannot be a sub-classification or micro-classification as rendered by the Supreme Court in E.V. Channaya's case. So how can you make classification? So if you make classification, you can't make, it's bad in law. So on the basis of that, 2016 rule was set aside. We further pointed out before the court in 2019, when this matter was decided by the division bench, relying on the E.V. Channaya's case, that why we made this classification. The percentage we have shown for the last 5 years. Court said don't show this percentage for the last 5 years because you have classified. So the main subject is if you cannot classify it, then those points goes. Classification will not work out, which you have shown or chart to us. So the division bench relies on the judgment of E.V. Channaya and said that your rule is violative of Article 14 and it is set aside and make a new rule. So 2021, we made a rule, my lord. Again, in this 2021 rule, if your lordship looks into it, there is a classification which we made. My learned friend says, how can you make classification? Whatever rules you framed in 2016 rule is a repetition. It's a repetition of 2016 rule which we made in 2021. Again, you made the same mistake of E.V. Chennai judgment, which was relied. That's the whole case, my lord. Now I will submit before lordship that there is nothing wrong which the state has made for further classification. My learned friend has shown the constitutional provision of 342. My learned friend has not read that after 342, there is an amendment insertion of the constitution in 342A.
In 2018.
In 2018. E.V. Chennai is in 2000, my lord, 2005. Constitutional amendment, your lordship will kindly see in 2018. So, all the judgment of E.V. Chennai, there was no constitutional amendment. My learned friend read 342 only. Kindly see the constitutional provision of 342A. And I will say with great respect, this is a better judgment because of the constitutional amendment of Devinder Singh judgment, my lord. Kindly see 342A. Kindly see, my lord.
We are concerned with 3.
We are concerned with 342A3, my lord. Lordship got it, my lord. 342 is the scheduled tribes. 342A, my lord. Lordship got it. 8. Please go down below. Please go down below. It is insertion of by the constitution in with effect from 11/8/2018. Lordship got it. Your lordship, if your lordship goes down below, see the insertion which has been made in 11/8/2018. 342A. My lord, footnote, your lordship got it. Now kindly see 342A3, my lord. We are concerned about 342A. Lordship got it. 342A3. Notwithstanding anything contained in clause 1 and 2, every state, notwithstanding anything contained in clause 1 and 2, which is the parliament, my lord, 1 and 2, every state or union territory may by law prepare and maintain for its own purpose a list of socially and educationally backward classes entries which may be different from the central list. So the power has been given to the state by way of insertion of 342A, and which our case falls in 342A3. So this power has been given to the state, and accordingly state can definitely can classify. They have to look into it, a list of socially and educational backward classes. So, my lord, this judgment, this 342A has been interpreted by a judgment of the apex court. Strength of the E.V. Chennai 5 judges is same by Devender Singh, that is 5 judges. They respectfully differs. They said if Devender said the E.V. Chennai should be revisited because of there is a constitutional amendment
And subsequent development.
which has taken place, my lord. So my learned friend said one judgment of the apex court shown when it is shown for FNI show that judgment is completely on a different footing. How when the matter came up, E.V. Chennai's, the subject matter was the same. In Devender Singh, kindly see Devender Singh judgment, my lord. I have given this copies, my lord, before your lord. I think that's the issue where before this court also. Kindly see, my lord will keep in mind, please, my lord, 342A, E.V. Chennai's, at the time when it was decided, 342A was not there, my lord. 342A3 was not there. 342A itself was not there when E.V. Chennai was decided. Now kindly see 35, my lord. Para 35. Kindly see the strength of this judgment, my lord, of Devender Singh is 5 judges. Kindly see 5 judges. Your lordship will kindly note down. Same as Chennai, 5 judges.
Yes.
5. Now kindly see 35. That question, para 35. The question 35 is the question arising for consideration is whether sub-classification made of preferential treatment within the class of scheduled class, scheduled tribe, and socially and educationally backward classes can be said to be an exercise of inclusion or exclusion, particularly when the other caste in the list of scheduled caste persons are not deprived of the benefit of reservation in totality. All the cases included in the list of scheduled caste are given the benefit of reservation as per representation in service, but only specific percentage fixed for preferential treatment to a caste class which are not able to enjoy the benefit of reservation on account of their being more backward within the backward class of scheduled caste. The preferential treatment would not tantamount to excluding other classes as total deprivation caused to any of the caste in the list of scheduled caste under Article 342(1). Caste is nothing but a class. It is a case of classification to provide benefit to all and to those deprived of the benefit of reservation being the poorest of the poor. Whether the action based on intelligible differential to trickle down, the benefit can be said to be violative of Article 14 and 16 of the Constitution, and whether sub-classification can be said to be an act of inclusion or exclusion, particularly when various reports indicating that there is inequality inter se various castes included within the list of scheduled caste. They do not constitute homogeneous class having been relied upon. Based on the report and to give adequate representation to those who continue to remain the most backward of the downtrodden class, the provisions containing a certain percent of preferential treatment subject to availability without depriving others in the list were made. So now if your lordship further goes, this was the issue before your lordship, before the court, 5 judges, whether there can be a sub-classification or not among the scheduled tribes and whether the state is empowered to do it or not. So if my learned friend's submission and E.V. Chennai's submission is, my lord, taken into consideration, then sub-classification, there cannot be a sub-classification. But in view of the amendment, insertion of the constitutional amendment in 342A3, that sub-classification, that classification has been given to the state. So that point was this. That was the point before the 5 judges. So now, my lord, kindly see how it is discussed. What the apex code 47 kindly be seen, my lord. 47. The Constitution is an effective tool of social transformation, removal of inequalities, intends to wipe up tears from every eye. The social realities cannot be ignored and overlooked, while the Constitution aims at the comprehensive removal of the disparity. The very purpose of providing reservation is to take care of disparities. The Constitution takes care of inequalities. There are unequals within the list of scheduled castes, scheduled tribes, and socially and educational backward classes. Various reports indicate that scheduled castes and scheduled tribes do not constitute a homogeneous group. The inspiration of equal treatment of the lowest strata, to whom the fruits of reservation have not effectively reached, remains a dream. At the same time, various castes by the large remains where they were, and they remain unequals. Are they destined to carry the backwards till eternity? Now kindly see 49. Providing a percentage of reservation within permissible limit is within the power of the state legislature. It cannot be deprived of its concomitant power to make reasonable classification within the particular classes of scheduled caste, scheduled tribe, and socially and educationally backward classes without depriving others in the list. To achieve the real purpose of reservation within constitutional dynamics, needy can always be given benefits. Otherwise, it would mean the inequality is being perpetuated within the class if preferential classification is not made, ensuring benefit to all.
Now 51 is important.
Now kindly see 51. 51 is important. The scheduled caste, as per presidential list, are not frozen. Lordship got it, my lord? If you argue on 342, it is frozen. Now here judges, 5 judges says 51. The scheduled caste as per presidential list are not frozen for all the time, and neither they are homogeneous group, as evident from the vast anthropological and statistical data collected by various commissions. The state law of preferential treatment to a limited extent does not amend the list. It adopts the list as it is. The state law intends to provide reservation for all scheduled castes in a pragmatic manner based on statistical data. It distributes the benefit of reservation based on need of each scheduled caste. It is same. The statistical data was not considered. It was same in 2019. Because why, my lord? My statistical data, which was given at in 2019, that was not considered because of 2020. That judgment, EV Channa judgment still holds good, because 2020 only this judgment came into effect. But 2019, when I showed the data, that data was not taken into consideration by learned court, because where is the question of a classification? There cannot be a sub-classification in EV Channa's case. That was made very clear. We give a data, statistical data. Here also we have annexed that data. I'll show it, my lord. We have annexed the data. What is the percentage of the Chakmas or non-Mizo ST? Ultimately, it boils down to 2 seats for the last 5 years. I will show it. All these seats will remain vacant. So we have given a data. That time, in 2019, when the court looked into it, court said, how can we look into it? We cannot look into your data because of EV Channa's case. Now kindly see the judgment, 2020 judgment. This paragraph, that's why I read paragraph 51. It doesn't get frozen at all. So it is on the state. That's why 51 is very clear, my lord.
And 48 talks about the state power.
And 48, my lord, talks about the state power. 48 talks about the state power. 48. Now kindly see how the court, 58, now kindly see. The last paragraph, 58, kindly look into it, my lord. We endorse the opinion of a bench of 3 judges that EV Channa is required to be revisited by a larger bench. More so, in view of further development, an amendment of the constitution. Lordship, now kindly see amendment of the constitution of 2018, which have taken place. We cannot revisit E.V. Chennai being bench of coordinate strength. We request the Honorable Chief Justice to place the matter before a bench comprising of 7 judges or more as considered applicable. Now, how your Lordship, can your Lordship now rely on E.V. Chennai's case? One, there is an amendment to it, 342A3, which empowers the state. That is precisely Devendra Singh in last paragraph says, sorry, we can't, it has to be revisited. Let it place before the learned Chief Justice.
Chennai does not consider statistical data.
And whatever Chennai has, my lord, there cannot be any statistical data in view of Chennai's case, because there cannot be any classification. There is a question of relying on statistical data. So, my lord, this matter, now what I have gathered, that this matter has to be placed by Chief Justice. It has been placed, but there is no, the larger bench has not been constituted to decide the issue in view of the constitutional amendment. Now, what I found, my lord, exactly on a similar situation in Patna and High Court, division bench, the issue was propped up, same, my lord, same issue has propped up. Kindly see how they dealt a division bench of Patna High Court. Same issue, classification. How it was dealt, both the matter, both the judgment was placed, and how the Patna High Court dealt it. That's the Chief Justice or Normal Justice S. Kumar, my lord. Now I think the Chief Justice with great respect is in Apex Court, my Supreme Court, my lord. Same Chief Justice. Justice Punazil Karol, my lord. My lord will kindly see. What was it? Yes. Yes. This order is of 3/9/2020. Lordship, kindly note down 3/9/2020. Kindly see the prayer. Next page, my lord. Prayer 1. That the unconstitutional impugned resolution dated 30/8/2017, bearing memo number 2950, issued by Government of Bihar without following the mandatory provision under Article 338(9) of the Indian Constitution contained in Annexure 10, and its all subsequent recommendation may kindly be finally set aside. Because, my lord will note down, because it is unconstitutional and violative of Presidential Order of Government of India 1950. And by this impugned resolution, the Bihar government has constituted a Rajya Mahadalit Ayog, making micro classification of scheduled caste of Bihar state. Lordship got it, my lord? This is the same. Now, now kindly see, this was the issue. Now, how the court at next page, my lord, kindly see next page. Next page. In support of this his contention, Learned Counsel for the petitioner invites our attention to the decision rendered by Honorable Apex Court in 2005, 1 SS 394, titled as E.V. Chennai versus State of Andhra Pradesh. In opposition of the petition, Sri Pavan Kumar, Learned Counsel appearing for the state, invites our attention to the most recent constitutional bench 5-judge decision dated 27/8/2020 of the Honorable Apex Court in civil appeal number so and so, State of Punjab versus Devendra Singh. We find that the latest constitutional bench, also same judge strength, has differed with the view taken in E.V. Chennai's case. In fact, they had gone to the extent of holding that it is permissible for the state to identify and confer benefits to the certain person on the basis of social and economic disparity. However, we find that only to maintain judicial discipline, the matter was referred to larger bench for revisiting the decision rendered in E.V. Chennai's case, Chopra. We noticed that the instant petition was filed on 25/2/2020 and no interim order was passed in favor of the petition. The action of the state stands implemented to the marginalized
an economically backward person among the scheduled caste. In that view of the matter, we are of the considered view that the present petition can be disposed of on the following terms. Parties shall be bound by the outcome of decision rendered by the larger bench of the Honorable Supreme Court of India. Reference thereof is made in State of Punjab versus Devinder Singh. Petitioner can approach this court on the same and subsequent cause of action if need so arises subsequent to the said decision. So, my lord, the entire petition was disposed of on the ground that judicial discipline propriety should be maintained. So, let it be decided by the apex court. Thereafter, the matter can be taken up. So, that's the view. And normally, my lord, your lordship also normally maintains a judicial discipline and consistency are being maintained, which in Supreme Court in 1960 also said one has to maintain. Unless you can distinguish both. Here, my lord, your lordship is subject matter is the same. Is a classification, sub-classification, micro-classification, whether it can be made or not. So, if it is, it can be distinguished, yes. But if the subject matter is the same, because the crust of the empire matter is the sub-classification, micro-classification. And my lord will kindly see, I think Devinder Singh judgment of 2020 is based on 2018 the constitutional amendment, insertion of the amendment, 342(2) and the statistical data. Now, if your lordship kindly look into it, 360, I think one judgment of the Supreme Court, this only. Para 19, kindly see, my lord. Para 19 of the Apex Court judgment, 1960, Supreme Court 936.
19.
I have given 1960 Supreme Court 936. Kindly see 19, my lord. Constitutional mention. Three judges. Para 19. Before we part, lordship got it? Yes. Before we part with this appeal, however, it is our duty to refer to one incidental matter. We have noticed with some regret when the earlier decision of two judges of the same High Court in Deo Ranjan's case was cited before the learned judge who heard the present appeal, they took on themselves to say that the previous decision was wrong instead of following the usual procedure in case of difference of opinion with an earlier decision or of referring the question to a larger bench. Judicial decorum, no less than legal propriety, forms the basis of judicial procedure. If one thing is more necessary in law than any other thing, it is the quality of certainty. The quality would totally disappear if judges of coordinate jurisdiction in a high court start overruling one another decision. If one division bench of a high court is unable to distinguish a previous decision of another division bench and holding the view that the earlier decision is wrong itself gives effect to that, view, the result would be utter confusion. The position would be equally bad where a judge sitting singly in the High Court is of the opinion that the previous decision of another single judge on a question of law is wrong and gives effect to that view instead of referring the matter to a larger bench. In such a case, lawyers would not know how to advise their clients, and all courts subordinate to the High Court would find themselves in an embarrassing position of having to choose between disentitlement judgments of their own High Court. So rightly, my lord, I think the Patna High Court has observed that when the E.V. Channa judgment has been referred, so I think we should wait till the judgment is being passed.
What do you say about this?
Now I will show. Now before that, my lord, I'll show the judgment of my learned friend which is cited. Before that, I will show the judgment of the court at page 71, which my learned friend has referred to this writ petition to PIL, sorry, my lord, PIL, my lord.
Page?
71. I'll not trouble with the judgment. My learned friend has read paragraph 17, which was a crust of the issue at 17. Because your lordship kindly see 17, my lord. Once again, 17.
Yes.
And with the question that arises for consider is whether for the purpose allotment of seat categorization as contemplated in category 1 and 2 could have been legally made. That was the, my lord, issue before the division bench. So on the decision of the issue of a classification, whether you can make a classification among the ST, that was the issue before the court. The facts in Ivichana were that the state of Andhra Pradesh appointed a commission to identify the groups among the scheduled castes found in the list prepared by precedents under Article 341 of the Constitution would had failed to secure the benefit of reservation provided for scheduled castes in the state in a manner of admission to professional colleges, admission to professional colleges and appointment to service in the state. So that was the issue, my lord, before the division bench. Now, my lord, will if your lordship kindly see at page 71 from the third line from top at page 71. Lordship got it? The objective of classification under Rule 5 is stated to be to reserve percentage of seat for the purpose of admission in higher educational institution. If that be the objective, the scheduled tribes who figure in the Constitutional Scheduled Tribes Order 1950 and who are permanent resident of state of Mizoram could not have been placed in two different categories of permanent residents. So if the Presidential Order of 1950 says that there cannot be any classification, how you classify? You cannot classify. Now, any attempt, now further your lordship, any attempt to differentiate the member of scheduled tribes who figure in the presidential list under the Constitutional Scheduled Tribes Order 1950 by any parameter such as permanent residency, etc., would amount to fiddling and tinkering with the presidential list, which is not permissible in law. Absolutely correct. My lord, 1950 presidential, you cannot tinker with the presidential list. How can you tinker? Till 2018. But 2018, my lord, there was a change.
It's no longer a frozen.
So it's no longer a frozen list. Lordship has seen the judgment of Devinder Singh. Is no longer a frozen list. Why? Because of the 342A and 3. Now kindly see further what the learned division bench with great respect have said. Benefit of reservation has to be uniformly applied to all the scheduled tribes listed under the Constitutional Scheduled Tribes Order 1950. And it cannot be countenanced that one tribe would get higher percent of reservation, another lower. So in that backdrop, now kindly see, in that backdrop, the basis of categorization, whether it was on the basis of performance in ST for the last 5 years or on the basis of appearance of student in ST in the last 5 years, carries no significance. So my statistical data, which was given, my lord, that court said we will not consider that statistical data. The basic foundation is the classification you cannot make it. You cannot tinker with the 1950 presidential order. Where is the question of giving that list? So what is our data? Kindly see, my lord. Now, if Devinder Singh judgment, my lord, it is held by a larger bench that yes, it is a prerogative of the state because of 342A3, then my data, my lord, my data has to be taken into consideration, my lord. What data I have given, kindly look into it by affidavit.
Affidavit in opposition in writ petition 286.
So, my lord, the affidavit by the state in the writ petition 285.
Percentages. Based on the percentage of 600.
Lordship got it, my lord. The affidavit 285 of 2020.
Is it by joint director?
Yes, it is joint director.
Higher and technical.
Lordship got it? Joint director. Lordship, Kindly see page 12, my lord. No, kindly see page 11, 8.7. 8.7. If you rely, my lord, 342A3, this data was given basis of 342A3 subsequently, my lord. Kindly see 8.7. It is pertinent to note that almost the entire population of state of Mizoram consists of scheduled tribes, and majority population belong to geo-ethnic scheduled tribe, that is Mizo ST. In fact, the Higher and Technical Education Department, Government of Mizoram, has collaborated with data for the past 5 years with regard to number of candidates appearing for competitive examination, along with the percent of Mizo ST and non-Mizo ST. The said data is set out in a table where herein below for easy reference. Now kindly see year-wise, we made a data, my lord, 2017, kindly see first. Number of candidate in 2017, medical MBBS. It is MBBS, my lord. It was 1566. Lordship got it? All professional courses, my lord. Not only MBBS, we have given list of all the professional courses. Number of geo-ethnic candidates is 1536. That is, my lord, Mizo ST candidate. Now, third column, number of non-geo-ethnic candidate, 38, my lord, non-Mizo ST. Lordship got it? Non-Mizo ST. Now, Chakma candidate is 22. Then percentage of geo-ethnic candidate is 98.1 Mizo ST. Now, percentage of non-geo-ethnic candidate is 98.1. That is Mizo ST. Percentage of non-geo-ethnic candidate is 2.4. That is, my lord, non-Mizo ST. Now, percent of Chakma and candidate is 1.4. This is the data which has been given. Up to 2021, kindly see at page 13, my lord. 2021. Up to the total, kindly see, my lord. Total, if you plus all this, total Mizo candidates is 8993. Kindly see, my lord. 5 years we calculate total number of candidates 9238. Lordship got it? And total number of Mizo candidates 8993. If you plus all these 5 years, now non-Mizo candidates 182. Now Chakma for 5 years it becomes 90. And Mizo candidate is 97.4%. And non-Mizo candidate is 1.97%. And Chakma is 1.01%. So if, my lord, if this data is not being prepared by us, so ultimately what it remains ultimate will be, all these seats will be kept vacant. That's why this data was given. But this data was not considered by the learned division bench at the relevant time because of Imbi Channa's case. And that time, when it was decided, my lord, 2018 amendment, the 342A was there. But that was noticed by Devinder Singh. They noticed, the learned judges, 5 judges have noticed that there is a constitutional amendment insertion of 342A.
And statistics state-wise is important.
Then statistics state-wise is important. That can be taken into consideration. So the best part, why your lordship will take into consideration unless it's not been decided by the larger bench. That is why, my lord, the Patna High Court says, sorry, we can't decide it. Let it be decided by the 9 judges, by more larger benches. They will decide the issue. Till then, we will not decide. So on the very first day, my submission, your lordship was not there, a part of the bench, my lord. I told your lordship that lordship will keep this particular matter till it is decided by apex court. Because your lordship, with great respect, but how your lordship, it's a difference. Subject matter being the same. I could have appreciated the subject matter was different. The subject matter is same, my lord. Your lordship has seen the classification.
Law laid down under 141.
So both law has been laid by the apex court under 141. Imbi Channa is a 141. Devinder Singh is also 141, my lord. So your lordship is now with great respect fixed. What will do it? the state of, my lord, Patna High Court also was fixed when the matter came up. But they said we'll dispose of. Let us wait till the judgment is being passed by the apex court. No alternative, my lord. My lord, I have seen there are certain cases which we move here. And this goes division bench, single bench passed in our favor. The division bench also upheld the order of the single bench. Now the party goes to the apex court. There is no interim order passed by the apex court. Even division bench say, please, we'll wait till the judgment is being passed. There is no interim order passed by the apex court. So, but judicial disciplines are being maintained. Let us wait till the judgment is being passed. So now I will show the judgment which my learned friend has shown.
Para 1.
I think this is totally a different altogether.
Two was different.
Issue was different.
Issue in the reference and the issue in the judgment.
Or reference.
Reference और issue है तो पहले या तो 1 और 26 पहले होगा A2 say A2 a case or issue reference or issue to Belek, which is the finding given at para 26.
Yes,
This-
before.
I just,
Yes.
one query that as per 342A, your requirement of making a law.
Hmm.
Just come to 342.
Yes.
In terms of 342A,
Yeah.
you need to make an enactment. This is an enactment.
This is a rule which we made. 2021, we made the rule.
This is a rule.
This is a rule which we made.
There's a difference.
Yes,
Enactment by the legislature
yes.
and the rule. Rule under which provision this rule has been made.
Under 309, 309 rules has been framed.
You just read the 342(3).
Not to say anything contained in clause 1 and 2. Every state or union territory may, by law, prepare and maintain for his own.
Prepare and maintain.
Yes, for his own purpose, list of social and education. We have a report. We made that report. Because when it came before a division bench on an issue on this, that whether that list has been prepared, socially backward classes, we made a list, my lord.
So this
There was a committee which
first
was.
enactment law has to be there
Yes,
by preparing and maintaining.
yes.
Yes. So there is.
For maintenance and preparation, you have to enact a
So, my
law.
lord.
Then under that law, you can maintain and prepare.
Why we made a law? Why we made a law in 2002? I'll give a reply, quick reply to what your lordships has made a query to it. My lord, 2021, we made this particular because there was an order passed by division bench. Set aside your 2019, that 2016 rules, because you cannot classify it. Ultimate, we have made a statistical data on what basis percentage for last 5 years. On the basis of that data, we changed in 2021, we amended and made it. We maintained that, and in 2021, we made that.
Only that rule was amended.
Only, my lord, 2000, that rule was amended.
Rule 5.
Rule 5. Only Rule 5 was amended in view of the Judgment of the division bench.
Otherwise, the rule is existing from 16.
2016, the rule was existing, my
No,
lord.
that rule making power, the
Yes.
state has, that is something different,
Yes,
according to us,
yes.
because it gives you a power to enact a law for preparation and maintenance.
My lord, my lord, one second.
To
My lord,
prepare and maintain, you have to enact a law.
suppose,
Then under that law, you will be, you will have a power. After enacting that law, only you can maintain and prepare the list of classification, which can be classified, and consequently you can have the rule
suppose,
classification.
suppose I accept what your lordship has said. Now, secondly, going to that, that means, my lord, my learned friend's argument in respect of the classification that holds no good, my lord. As on date,
Of course, that may have a different.
no, that's the whole crust of the entire issue, my lord. The crust of the issue is this, my lord. We cannot tinker with the presidential order of 1950. So there cannot be any classification. That's what I understand, my lord. That's what my learned friend is advancing, my lord. So, and my learned friend is saying already the judgment is rendered by division bench.
Para 33 of it was the Devendra Singh para 33.
My lord, kindly see paragraph 33 of Devendra Singh, my lord.
This query is answered.
This, your lordship's query, I think, what my learned friend is saying is answered. Para 33, my lord. Kindly see para 33 of Devendra Singh judgment. 33. Page 54 of Devendra Singh judgment, my lord. Lordship got it, my lord? Can I read, my lord?
Just a minute. Yes.
Article 342A has been inserted by the Constitution, 1 Second Amendment, Act 2018 with effect from 14/8/2018. In Ras 1 is the question of reservation of socially and educationally backward classes was involved. Article 342A provisions are parametria with Articles 341 and 342 dealing with the scheduled castes and scheduled tribes. Under Article 342A, the President is empowered to issue public notification with respect to socially, educationally backward classes, which shall for the Constitution be deemed to be socially and educationally backward classes in relation to the state or union territory, and Parliament may by law has the power to include it or exclude from the central list of socially and educationally backward class. The power of variation can be exercised only once. When we consider definition of socially and educationally backward classes as defined in Article 366, 26C, it means such backward classes are so deemed under Article 342A for the purpose of Constitution. In order to be recognized, it is necessary that socially and educational backward class to find a place in the notification issued under Article 342A(1). The provision of Article 341 and 342 and 342A are perimeteria, and the reservation of socially and educationally backward classes for the subject matter under consideration in the Swami's case. Thus, the question arises, how different opinion can be expressed with respect to scheduled castes, scheduled tribes, and socially and educationally backward classes for the purpose of the classification. The provision of Article 16(4) and Article 342A indicates that it would not be permissible to adopt different criteria for scheduled caste, scheduled tribe, and socially and educational backward classes. The authoritative pronouncement is required with respect to the effect of the aforesaid provision of the Constitution and whether subclassification is permissible only with respect to socially and educationally backward classes covered under Article 342A, read with Article 366(26)(c), and not with respect to scheduled castes and scheduled tribes covered under similar provision, that is under Article 341 and 342, read with Article 366(24), 366(25) respectively. The question of immense public importance arises in view of insertion of Article 342A. When we consider Indra Swami permitting such classification of socially and educationally backward classes and provisions of Article 341 and 342 and 342A are perimetrial, this court is required to have a fresh look on the decision rendered in which and as in the spirit of constitutional provision, question is required to be re-examined authoritatively by this court being of immense public importance. Thus, the case is required to be heard by a larger bench than one which decided in which and as.
Precisely, the power, the manner in which it is to be exercised is going to be decided by the matter.
So this issue has to be decided by a larger bench. That is why it was referred, my lord, or this subject, my lord.
What do you say on the judgment given by the other side?
This judgment is something different, my with great respect, I will say, my lord. Kindly see the judgment referred by my learned friend. Kindly see what was the issue involved. Kindly see the issue involved in paragraph 1. Kindly see what was the issue in paragraph 1.
Yes.
The issue which has been raised in this writ petition is whether an offence which is not compoundable under the provision of Criminal Procedure Code referred to as CRP can be quashed in the facts and circumstances of the case. That's the issue, my lord.
See what is referred at 26.
Now, kindly see what is referred at page 26, my lord,
To a larger,
to a larger bench. 26, my lord.
that is 16 for the bench. That one is 16.
Para 16, I think. Your lordship, I think para 16.
Here's a difference. We are having some problem with the
Para 16, I think, my lord.
Just read it out.
The furthermore,
Furthermore, 16 or 19.
16 or 18, I think. Furthermore,
Para starts with furthermore.
furthermore,
One minute.
Furthermore, the issue which has been referred to a larger bench. Furthermore, the issue which has been referred to a larger bench in Gyan Singh case.
1 minute. 1 minute. Para 19.
Furthermore, the issue which has been referred to a larger bench in Gyan Singh case. Okay. Well, can be helped, my lord. Give one judgment, one topic. We just help it. It's not this judgment, something else is saying, my lord. Reference is on a different subject. The issue involved in the present case was different. So the judge, the honorable judge has said this thing is different altogether. I mean, furthermore, the issue.
And we have a copy from the SCC. Huh?
Yes, we'll just mark, tick mark and this.
With 11 S.
I think page 10, my lord. And it's page 10.
It's in the middle of the paragraph.
Middle of the
Oh,
paragraph.
it's in the middle of.
It's in middle of the paragraph, yes.
I just keep it say to legal. Man.
Legal. It is in markets.
Okay.
Furthermore, the issue which has been referred to a larger bench in Gyan Singh case in relation to the decision of this court in B.H. Joshi case, Nikhil Merchant case, as also deals with a situation which is different from the present case. Lordship got it, my lord?
Yes.
While in the case referred to in here above, the main question whether offense which were not compoundable under section 320 CRPC could be quashed under section 482. In Gyan Singh case, the court was of the view that is a non-compoundable offense could not have been compounded, and the court should not try to take over the function of parliament or the executive. In fact, none of the case referred did this court permit compounding or not compounding offenses. On the other hand, upon various factors including the futility of continuing with the criminal proceeding, this court ultimately was different The reference was on different subject altogether.
Issue in the matter was different.
Issue was different, reference, referendum was different, my lord. How can this, my lord, judgment, my learned friend can rely?
Whereas Patna is straight on the point.
And your lordship has seen the Patna High Court straight on the point.
Same two judgment.
Same to the two judges, my lord.
No SLP has been filed.
As on date, we checked also, my lord, there is no SLP against that order. And no one will find SLP, my lord. When the five judges, strength is equal of Devinder Singh and E.V. Chennai. Why an SLP will be filed, my lord, when a reference has been made to Chief Justice?
And High Court has given them liberty to come back after the larger bench.
Once it is decided, then again they will come back.
Liberty can be done. Why I couldn't interpret it? There is a situation which is different from the present case. It would have had a 31, the ratio and decision of so and so does not help the particular.
But it would pay 31 but here, ultimate. My lord. Last two paragraphs, I don't know, might be different again. What it says, the ratio of the issues.
Same judgment.
Same, which I'm reading the Mr. Chaudhary judgment, my lord. That what he relied on. The ratio of the decision in B.H. Joshi case and Nikhil Merchant case, or for that matter, even in Manoj Sharma case, does not help the case of the writ petition. In so and say the court had in facts of case observed, involve overtouch of civil and so and so. This is not so the instant case where the emphasis is more on a criminal intent of petitioner that on civil aspect views of so and so. So we are inclined to grant the relief, so and so. So that's my submission, my lord. No, my lord, that's what view of the Devender Singh judgment. I'll rest my argument with saying that lordship should wait till the judgment is passed by the apex court. See, and follow also Patna High.
OBC.
And my learned friend answers. And so far as 2020, then my learned friend said that he came once in the High Court and there was an order. It was completely, if your lordship calls that, that was complete. I appeared in that. They came very late in the month of January, after admission was over. And they relied on some all India quota, some examination. So there was some interim order. Then we clarified the court that no, that's not a situation. Admission was over.
That's why you never press.
So they never praised the contempt, my lord.
Now the contempt petitioners got admission.
So now they got admission in pursuant to court's order. We, my lord, there is some system which we applied because ultimately it has to be this, the admission takes place by the government of India. It has to be referred to them only. Well, there is a portal, which portal they can only open that portal. Ultimately, it has been done and ultimately admission has taken place in view of the court's order, my lord.
Portal is open and close also.
Portal open and close. Further, now if you again want to open it, my lord, there are some orders to be passed.
then again we have to write to them. Again, we have to write to them, my lord. Why it got delayed? We wrote to the government. There's a portal which they opened and they say there is an order passed by the court, please comply. We complied that order, my lord. That's my submission. my lord.
Which is the provision?
Your Lordship, please, I may.
You are in IA.
Yes, my lord.
IA
My lord,
number?
IA number 1297 and 12.
With your lordship, I will just, I will take a leave, my lord. I will come back.
So my lord, that one IA is for implement,
1 minute.
1, 2.
IA
1295 and 1297, my lord. So my lord, my IA basically for filling up of that one vacant, still vacant, to the next, the one who got the highest mark. So my lord, if you kindly see this, my IA at page number,
Lalu Sanga,
yes, my lord.
you are approaching this court by way of an IA.
IA, my lord.
How?
My lord, here, even earlier also, like in the
IA in
same
which case?
IA in that WPIL. Because the same manner also, my IA, this 469 was also disposed. Because in that IA, the one who got lower mark was allotted seat. In the same manner, we come again. Everything same, except name and grounds.
Have you been impleted?
Yes, my lord.
You've been impleted as party.
That actually, my lord, in that IA, it was disposed of together.
No, no.
Implement along
In
with,
this PIL, have you sought for an implement?
yes, my lord. One is for IA for implement. One is for IA for modification of the order. My lord, one thing,
Whether you have been impleted or not, or
My
are
lord,
you
I have
seeking for implement?
both I submit along together.
First, you have to implement.
Yes, of course, my lord.
You have been impleted or not?
So far, today is the first listing of both IA together, my lord. Because my lord, admission has already started November. My lord, kindly see 1 day absence in the class is very fatal for their career also. Now it's almost five months. This applicant is not able to study because of this pending. Because my lord, if you kindly see the order, everything will be very clear.
Which order?
That order, page number 13, in that my IA,
Number?
page number IA that 1297.
Here you are writing para 71, there is no para 72. If you look from the page.
Page number 13.
IA 1297.
Yes, my lord.
I have only up to page 7.
Oh, my lord, that it will be, I think, 1295. Because just seeing the course list it is difficult which one is which.
That is
You have filed this IA, you should know which one is which.
My lord, this morning I just arrived from airport, I just came straight. And
When did you file this?
I think last week.
Yes.
Yes, yeah. So the order operating part starting from 15, page number 15.
Yes.
So am I kindly read, my lord? Mr. K.N. Chowdhury, Lanet Senior Counsel, assisted by Mrs. S. Chowdhury,
You can skip that.
see it like that. The core issue involved in this petition revolves around the claim of the 5 petitioners seeking admissions into the MBBS course in medical college run by the state of Mizoram. According to the such and such, the case of the petitioner is covered by the judgment and order dated 22 February 2019, passed in PIL number 49, 2016. Mr. Chowdhury submits that the writ petitions belong to the Chakma community, which is recognized as scheduled tribe community in the state of Mizoram, and therefore they would be entitled to the benefit of the state quota reserved for the ST category candidates. Mr. Chowdhury further argued that 3 seats in the MBBS course is still vacant, since the classes have already commenced and the petitioner have a strong prima facie case in their favor. An interim order be passed, directing the state to provisionally allow them to attend classes. The Lanet Senior for the writ petitioners has, however, fairly submitted that since there are 5 petitioners and only 3 seats are available in the top 3 candidates in order of merit, be accommodated for the present. Mr. D. Das, Lanet Advocate General Mizoram, submits that the government is examining the rules and therefore at this stage, it cannot be said whether amendment to the rule would be brought about in the near future. However, the Lanet AG has not denied or disputed the fact that the classes of MBBS course has already commenced for the current session. Mr. H.K. Das, Lanet Counsel, submits that his clients are already protected under the order of this court and therefore he would have no objection if any interim relief is granted to the writ petitioners. We have considered the submission made by the Lanet Counsel for both sides and also gone through the merits on record. From a perusal of the materials on record, it is prima facie appears that the case of the petitioner is covered by the judgment of this court rendered in PIL 49, 2016. Hence, instead of the interest of the petitioner's merit protection by an orders of this court, it is not in dispute that the classes of MBBS course for the current session has already commenced and 3 seats available at present. Therefore, if the 3 out of 5 petitioners are accommodated against those seats, no prejudice would be caused to either side. On the contrary, if the seats remain vacant and eventually the petitioners succeed in the petition, then in the event, enormous prejudice would be caused to the writ petition. Therefore, in regard to the peculiar facts and circumstances of the case, and adopting a balanced approach, we are of the considered opinion that the present is a fit case wherein an interim order is required to be passed. It is the undisputed positions of facts. The mark obtained by the 5 petitioners in the need are as follows. Number 1, Monica Devi Chakma, 334 marks. Renki Tongchoya, 291 marks.
You can skip that.
Harshika Chakma, 2, okay. Since there are only 3 vacant seats, the top 3 candidates would obviously be entitled for consideration as this states. Issue notice of motion returnable on 30th 1st, 2023. Since all the respondents are represented, no formal require is required to be sent in this case. The parties have exchanged their pleadings. Therefore, an attempt would be made to dispose of the writ petition at the stage of admission. As an interim measure, it is thereby provided that the writ petitioners, Monica Devi, Renki Tonchonia, Harshika Chakma be provisionally admitted and permitted to attend in the classes in MBBS course, which would, however, be subject to further order that may be passed in this petition. So, my lord, among these 5, only 3 were provisionally allotted by this interim order, which is subject to modification. So, by mistake, that this order was passed because Harshika Chakma was given seats instead of those who got higher mark. So we'll file writ petition that then order was passed. So that it was the order 6-1 was modified. Then, my lord, that number 2, she declined. She studied in some other college. So, my lord, I would like to kindly go to the merit, the results also. My lord, here is at 29. Kindly go to that 29 page number 29. rank number 87 is the one who got higher mark than Renki Chakma, who was given seats by order of this court in 9th May 2022. And this 88 rank, Debbie Enkimi, declined the seats. So she had written no objection also, which I have also enclosed. And she submitted that I'm not interested and I do not have any objection to for the seats to Sila Road Moya, applicant in this IA. So, my lord, here I don't think like anyone has objected because MBBS seat is very precious. So it's determined the lifetime careers of one particular candidate.
Where's the applicant's name? Which
Here at 89, rank number 89.
is the applicant?
Yes. Isaac Lalthana, 87, already got admission. Now he's studying MBBS at ZMC. 89 she declined. 88 is the present one. So that the vacant seat now, that
Who's
number,
the present applicant? Who's the present applicant?
this Sila Road Moya.
89.
Yes, 89, my lord. My lord, the order in Pune order which I show for modification is also at the last para. This is subject to modification. It was clearly written at the very last para.
Where?
At page number 17. Page number 17. Very last para. As an interim measure, it is hereby provided that the writ petitioner Moninta Devi Chakma and this number 2, the one who got admission in another college, Rengit Tonchongia, Harsika Chakma, be provisionally admitted and permitted to attend the classes in MBBS course, which would, however, be subject to further order that may be passed in these petitions. This is very clear because only here among these three, Monita Devi got admission. Number 2, she studied in another college. Number 3, by modification order 9/3/2022, her admissions was cancelled by this court, and that rank number 87 was given. No prejudice would be caused to any party in these matters. So I don't expect any objection from any parties in this case, my lord. Because they already started class for almost five months. And he is desperate to study. Because one day absence in the class really fatal.
He has to be implemented first, no? You have to be implemented first, whether
Yes.
Mr. Chowdhury has any
Well,
objection.
as I already submitted, my lord, it's not a question of my lord. End of the day, this procedure of this honorable court has to have some sanctity. He cannot, my lord, as a respondent, he cannot seek relief in my petition. That's a fundamental principle of law. So let him make the same argument by filing a writ petition in Aizawl bench. Why my learned friend is traveling to Guwahati? Because this relief can be given to him by the learned single judge of this honorable court. How can I'll definitely object, my lord. We are fighting for the last so many years. Till that our rights have not been ventilated. On top of that, they are seeking, she wants to become a party in my case as a respondent and seek relief. Which law permits it, my lord? It's a fundamental principle of law. As an OP, he cannot seek relief in somebody else's case. Let my learned friend file a writ petition in the Aizawl bench and he may be given an appropriate order. He's not even required to make us party there. I think it will be very difficult for lordships to accept his prayer in the present form. Well, I'll just take 10 minutes time to reply to what my learned friend Mr. Das has argued, my lord. Yes. My lord, my learned friend has referred to 342A3.
My lord, I am for the impleaded respondents in the writ petition. In the PIL, I am not a party, my lord. We have been admitted. The writ petition, basically, I am there, my lord. We have been admitted, and as per my instruction, both of the petitioners have been admitted.
My lord, before my learned friend,
The one did not get it. No, my.
I think my learned friend did not even submit also, my lord. Now, I don't think his clients will be interfered anyway.
If my clients are not being interfered, my lord, I'll not.
No, no,
open them.
for the purpose of the, what had happened? What had
I'll not
already,
open,
no,
my
no. No, my lord. We were 3. Out of
No, no,
which
no.
1 got admission. The second, my lord, she took admission somewhere else. And third, because of mark, possibly she cannot get. So therefore, at this stage, displacing my learned friend's client may not arise. For at this stage. For the future admissions to take place, that's a different aspect.
My lord, we have been admitted. If my lord observes, makes the records that observation, my lord, I'm closing my arguments. I'm not going any further.
You are admitted by 9-3 order.
No, we are admitted on merits, my lord.
A
without
stage,
this-
a
without
stage
this
came
orders.
in this proceeding where this honorable court felt, if we are to be accommodated, against which seat we will be accommodated. Naturally, we are 5. So court passed an order, whosoever is,
Five.
down below with 5 lesser marks, those candidates should be put to notice, because in the event writ petition or writ PIL is allowed, then they will be affected. That is how they came into the picture. Now, my lord, while that stage was going on, state made a submission. In spite of giving all these admissions, there are still 3 vacancies. Against that vacancy, one of us got it. So that way, my lord, I don't think any occasion will come to disturb my learned friends.
My lord may only record that.
Yes,
submission,
yes, yes.
For both the
Yes, yes.
PIL as well as this, my lord, I'll not make any submissions for.
No.
Because
This
why
doesn't,
am I
no, now
interested?
doesn't arise
No,
because.
I'll not make any submission. That's why I say. Why should I, my lord? My client's interest is protected.
Yes,
Why
yes.
should I?
So since you are there, you
Continue.
may make a submission on the reference, pending reference.
My lord, what had happened here in this, what I have understood, my lord, subject to what my lord would finally say. When Chinnappa was discussed, my lord, the 342 list was said to be 1, my lord. There could be no further classification between that list. Subsequent thereto, my lord, Chinnappa, my lord, one mistake, one aspect which was missed out in Chinnappa was it did not refer to Indra Shani's case, my lord. Indra Shani 1992 Supply 3 SCC was not taken in the manner it should have been taken. Because in Indra Shani, there is a prescription already made wherein it is said that within this backward classes, and my lord, Indra Shani says backward classes will also include scheduled caste and scheduled tribes. So in Indra Shani, my lord, the distinction was that the government for a given matter, for a given census data or something, can, my lord, provide for preference within that listed candidates. So that is why, my lord, if my lord leads Devendra Sharma, my lord, the latest one, therein, my lord, the Supreme Singh. Wherein, my lord, the Supreme Court had come to the conclusion that Chinnappa requires to be referred on the ground by discussing the proposition that was laid down in Indra Shani 11-judge bench and 342A, my lord. So it is on that very issue that the reference was made. And the Supreme Court in the penultimate paragraph, before making that reference, had categorically held, my lord, that this decision of Chinnappa that you cannot further give benefit to the different classes in a different manner is not the correct law. And the law which is now growing, they said that the constitutional law is a growing law. So by referring, by Chinnappa had, my lord, foreclosed everything. Chinnappa, E.V. Chinnappa. Chinnaya, sorry, my lord, it foreclosed everything, my lord. So my submission is, my lord, subject to what my lord would say after hearing my senior, that the reference being on the very issue wherein, my lord, the earlier decision of this honorable court was singularly following E.V. Chinnaya. There was no other, my lord, principle that emanates from the earlier judgment of this honorable court, which is now being referred here. So that issue now being referred, my lord, this issue, because the students who are there, they are protected now, my lord. My lord, this matter can be deferred till the, my lord, the decision of the Supreme Court comes. Much obliged. So this as an officer of the court, not as an officer of the people. Much obliged.
My lord, let us assume the reference is answered in favor of, as was sought to be, my lord, referred in this Devinder Singh's case. What will happen, my lord? 342A3 will come into play with full force. Now, what is the fulcrum? On what premise, my lord, the state will make the classification? The idea is what? Idea who is amongst the backward class who are more backward. Now, can we say Mizos are more backward than Sakmas? Is this the test, my lord? My lord will kindly have Devinder Singh judgment for a moment. I'll just refer to 2-3 paragraphs. Please come to para 43 first. And 49 in your lordship's paper book. Sorry, in the judgment.
Devinder.
Yes. Let us test the case from the perspective that eventually the reference is answered, as has been, my lord, referred by these 5 judgments. Para 49. Providing a percentage of reservation within permissible limit is within the power of the state legislatures. It cannot be deprived of its concomitant power to make reasonable classification within particular class of scheduled castes and scheduled tribes and socially and economically backward classes without depriving others in the list. To achieve the real purpose of reservation within constitutional dynamics, needy can always be given the benefit. Kindly mark this sentence, my lord. Why this, my lord? Amongst these, the socially backward classes, if there are some classes who are so backward that as far as they are concerned, some special treatment is to be given, then that is permitted. That's why 342A3 has been started with a non-obstante clause, notwithstanding anything contained in clause 1 and 2. The idea is needy can always be given the benefit. Otherwise, it would mean that inequality being perpetuated within the class if preferential classification is not made, ensuring benefit to all. Now, my lord, you are providing 90, how much percent? 94% to the geo-ethnic. You are giving only 4% to the others. 1% to the others, my lord. Is this the purpose of further classification? End of the day, my lord, every argument has to withstand some reasoning, my lord. It must lead to some logical conclusion. When Constitution recognizes the power of the state by of sub-article 3 of Article 342A, what Constitution meant, in my humble understanding, subject to what your lordship may say, is within that class, if there are people who need more attention, then that should be attended. And that power should be conceded to the state. Is that sought to be done in this case? Or they are to protect the already a group which is dominant, which is otherwise, my lord, from all perspective, they are well off. My lord, that's why I referred to this judgment in, my lord, this Jagadish Sharan's case. Please have the judgment for a moment, my lord. This is 1982 SCC 768.
Copy is yet to come.
Okay. Well, then I'll place the other paragraphs. In the meantime, I'll deal with this, my lord, Devinder Singh. So, my lord, from Devinder Singh, what follows is the power of the state in a given situation to address the needs of more needy amongst that socially backward section. If at all in the state of Mizoram, my lord, between Mizo and Sakma who require special attention, it is definitely Chakma. My lord, classification cannot be based on how many number of applications are filed. My lord, if on the basis of number of applications, a classification is to be made, that means you are giving up this socially backwardness. You are giving the, my lord, giving up the data of who is more educated, who is less educated. The data has to be with regard to, my lord, backwardness, inadequacy of representation. These are the relevant considerations, my lord, in my humble understanding. Then my lord will kindly come to paragraph number 45. 51 in your lordship's thing. Schedule caste as per presidential list are not frozen for all the time, and neither they are homogeneous group as evident from the vast anthropological and statistical data collected by various commissions. State law preferential treatment to a limited extent does not amend the list. It adopts the list as it is. State law, kindly see, the state law intends to provide reservation for all scheduled castes in a pragmatic manner based on statistical data. Now, which is that data, my lord? That geoethnic people are more backward, therefore more reservation is necessary. It distributes the benefit of reservation based on the needs of each of the scheduled caste. Then my lord will kindly come to para 48. That means 51, 52, 54. Apart from that, the other class out of the scheduled caste, scheduled tribe, socially and educationally backward classes, who is not denied the benefit of reservation, cannot claim that the whole or a part of the percentage of reservation should have been made available to them. State can provide such preference on rational criteria to the class within the list requiring upliftment. There is no vested right to claim that reservation should be at a particular percentage. It has to accord with ground reality, as no one can claim the right to enjoy the whole reservation. Well, it is going against the very argument of the state. It can be proportionate one as per requirement. The state cannot be deprived of measures for upliftment of various classes. At the same time, which is the very purpose of providing such measures, spirit of reservation is upliftment of all classes essential for nation's progress. My lord, idea behind making this reference was this power of the state needs to be recognized. Why? That's the issue, my lord. The issue is this benefit of reservation should percolate to all. On the contrary, my lord, with the help of this law, how can state of Mizoram claim, my lord, that they can make reservation of 94% for the, my lord, geoethnic people and 1% for other group? Does it stand to any logic? Is this the purpose of reservation? So therefore, my lord, when you are talking of, this newly added, my lord, provision in 2021, then you must advert to these aspects of the matter. The idea should be the benefit of reservation within that class should percolate to all. Not, my lord, as has been envisaged in the rule, only 1% for others and the rest are for them. So, my lord, the purpose for which this reference, we do not know what will happen eventually, my lord. Now, of course, since that constitutional amendment has come in recognizing some power, there may be some tinkering with the law. That's why I said, my lord, even if the reference is answered, what difference would it make in this case? Still, the position would be worse. It would be the other way around. That's why, my lord, in this judgment, this Jagadish Saran judgment, I think now it has come. If your lordship would kindly come to page 783. Now, this is the first judgment on this point of protective discrimination, my lord. Please come to para 34. Para 34, 1980. SCC 768, para 34. at page number 783. Thus, the constitutional principles and limitations are clear and the norms are belighted by the precedents, but their application to the specific situation is an exacting task. The burden when protective discrimination, promotional of equalization is pleaded is on the party who seek to justify ex specie deviation from equality. It is the state of Mizoram who will have to satisfy your lordships based on empirical data why they have made more reservation for the Geo-ethnic people and not for the others. The idea of incorporating that list within the meaning of Article 342 is not to help or support a dominant group. Idea is to, my lord, the benefits should go percolate to all. What has the Delhi University stated here? The learned Attorney General frankly admitted that student hesitation without more could not validate reservation and that excessive reservation was an obvious inequality. Nor indeed it is a good plea that illegal reservation is being practiced by other universities and the Delhi University is forced to act illegally in self-defense. Lawlessness under our system is corrected by law and not by counter lawlessness. So it is strange for Delhi University to say our disorderly behavior is orderly because the other universities behave similarly. Once these misguided defenses of direct action by the student or reprisal against such other universities are brushed aside, we come to grip with the real issues. Is there a circumstantial justification for constitutionalizing the reservation strategy, especially at 70% plus? So the Supreme Court posed the question, when you are making 70% plus for the Delhi, how are you doing it? Now kindly come to, my lord, paragraph 37. The argument asked in answer is that doors for admission to postgraduate medical courses are almost completely closed for Delhi graduates by all other universities. So protective reservation becomes necessary as the only hope of Delhi student for postgraduate studies. Those real life factors which show that Delhi graduates are denied de facto equality on a nominal scale by exclusionism of other universities and that therefore they deserve sheltered economy, equal opportunity is in actuality by barriers of reservation of a high percentage of seats. Such being the university's defense, kindly mark this sentence, my lord, must be made out, not merely asserted. That means by placing empirical data, this issue has to be not only pleaded, it has to be made out. My lord, end of the day, these are all matters of statistics. When Mizoram government want to take a stand that they would like to invoke the power under, my lord, 342 capital A sub article 3, then they must come up and place before this honorable court. These are the statistics, data based on which we propose to do this. They can't do because their stand itself is self-defeating. Instead of, my lord, percolating reservation, now they are centralizing the reservation in favor of a dominant group. This can't be permitted. But even that's why I said, even if Devinder Singh is answered, how does it help the state of Mizoram? Their case is just the opposite. The reason why Devinder Singh was referred, that's not the reason to be traced in the present case. Therefore, my humble submission is, my lord, as of date, the case is covered squarely by the earlier division bench, though an attempt is sought to be made that the issues are different is not correct, my lord. I have already read out from 2016 rules, where earlier it was 3 category, now it is 5 category. The same position obtains. And my lord, there is no manner of doubt that the Chakmas were displaced people from another country, my lord. They are more backward. If at all any reservation is to be made, for Chakma, this would have been separate reservations should have been made instead of the dominant group. So therefore, my lord, the argument of the state and my learned friend Nair, my lord, though he said that I, as an officer of the court, I am saying so, but towards the end he said one thing, that lordship should wait the outcome of the judgment. That was not fair. That submission was a very partisan. That was not as an officer of the court. He should have said, well, law as it stands today, Devinder Singh is yet to be answered. So Devinder Singh's reference will cannot withhold your lordship's decision. Your lordship is free to take a call depending on the whatever outcome or whatever view your lordship takes. Therefore, my humble submission is, my lord, when you plead this, protective discrimination, then it is your call to establish. It is not petition. As a writ petitioner, we need not, because it is a state who seeks to make that claim. Therefore, you must come with empirical data, which you have not. Therefore, in my humble submission, my lord, the plea of the state is perhaps not maintainable. That's my humble submission.
Only a very quick reply what my learned friend has said. My lord, that's what my learned friend structured the entire writ petition, the PIL as writ petition, and the query that has been put, and my learned friend relied on the judgment of a division bench. There cannot be classification, my lord, and which I said that there can be a classification in Devinder Singh case, and Devinder Singh case holds good as on date because that's not the case under 141. Ivichana is only 141. So Devinder Singh, what it takes the constitutional amendment into consideration. So my learned friend relies on that can be classification, no classification. So that's the entire trust of the entire case. That's my submission.
Devinder Singh has not decided any new law, my lord. It has sought to refer a case.
Refer a case on the basis of 342. 342A.
Mr. Teacher. And counsel for. Assisted by Mr. A. Kalita. The additional division as well as the Lalo Sound. And the counsel for the taken in by for 60. And 2023. The counsel for the private respondents in WBC number 285 of 2023.
I am for 8. I am for small 8.
Mr. K. Google for
Small 8 looks.
CGG for response number 8 in WBC. In WBC.
Deep.
If your lordship allows, there is a matter in the supplementary list where we were supposed to only submit the written argument. So I have made the written argument, I have given it to the court master. Even the petitioner. the
Lordship,
applicant has also-
I am submitting the written argument.
Who is that?
That
Item
is
16,
supplementary.
Came up as part head, Lordship, only for this purpose, Lordship.
Item 16.
16.
Yes, yes. That 6-year-old son murdered.
But Nurulkan, Leonard Damage Curie. Also had a message done and
The 2 copies I have given it to the court master.
Judgment reserved, Lordship.
Lordship.
Very big, I'm told.
Even I'm not very well, I'm having some headache, so
Let there be a fixed date, my lord.
Jahan, you're not well.
I'm having an headache, so any day. Not today.
Headache? You've got pressure?
No, not pressure. Because of gastritis, I get this headache.
Okay, you're.
I'm for 10, right? I'm AK Das.
I'm appearing for 11, item number 11.
This is, lordship will remember, this is Dhemaji bomb blast case, which occurred on 15th of August and many children died.
Oh, that I.
That matter.
This is way back in 2000
On
something.
request made by A.K. Das, Leonard Counsel for the appellant. In criminal April 3/11 of 2019. When do you want?
A week after next, my lord. We have only one day. 29th, no? 29th onwards.
Week starting from 10, any
29th. How long are you sitting here? How long will you take? You think it will take?
My lord, very difficult to say, but there are 60 witnesses. And the documents are so many It will take little time.
Witnesses are
Because it's an
mostly
appeal,
the,
my lord, we'll have to take your lordships to the every detail of it.
most of the witnesses were like onlookers. They were there. They,
Some of the witnesses are there.
Ah.
Yes, you're right.
they were simply there.
Okay.
29th Lordship will start.
Item 4, order.
Wait, please, your lordship, my lord. Here I am the amicus curiae, my lord. We have filed an application for bail, my lord. My lord, the applicant before your lordship, my lord, he is 90 years old as of today, my lord.
Objections?
But today it has come up for the first time. But
90-year-old man, my lord, languishing for the last 5
only
years. my lord.
ground is 90 years behind the bars. A person.
What threat will he be to society, my lord, if he is released, my lord? Because the judgment says on the date of judgment, he was 85 years. Judgment of 2018. So almost 90 years now, my lord.
Without going into the merits, of course, Honorable
Of course, my lord,
Supreme
without
Court
going
has
into
said
the merits.
age cannot be a factor in 389 application, but
That's what,
yes,
that's the reason why I'm asking.
age cannot be a factor. In fact, 85 years old lady bail was rejected by the Honorable Supreme Court. Here he is saying he is 90 years. And
I'm saying from the judgment itself, my lord.
Hmm.
I am the amicus here. I'm saying from the judgment itself, my lord. It is recorded that he was 85.
Let me, if your lordship thinks I can file an objection taking into view the merits as well as the age factor. I may not
Because
object
on the
to
merits
age
also,
factor.
if I may point out, my lord, paragraph 25 of the judgment, the learned court below holds, my lord, that there is corroborative evidence that the accused Lakhan Chauhan caught hold of the deceased and the accused Prem Sagar Chauhan hit the deceased on his neck with a dowel. So I am neither, my lord. I am Ram Naresh Chauhan. So there is no direct evidence that I had assaulted him. Anyway, my lord, I leave it to your lordship, my lord. If your lordship peruses paragraph 25 of the judgment, my lord,
Okay. You want to file your objection? Let her file within a short period of
let it
time.
be within a short period.
Age factor, I'll not object much, but let me go to the merits.
Let's see, even on marriage, let's see.
And let's,
You are Mr.
N. Decca, my lord.
Hurt and Decal and the amicus curiae appearing for the applicant. Stop. This is an application under section 389 within bracket 2 of the Code of Criminal Procedure 1973 for suspension of the conviction and sentence passed by the learned.
District Judge, my lord, learned decision Judge Karbi Angon.
What is the judgment?
Judgment is not there in the IA, my lord.
No, no, in the main paper.
In the paper book. The judgment dated 21/12/2018.
Passed by the London Sessions Judge Karbi Anglong Dipu in
My lord.
Sessions case number
That is 32. It should be 32 of 1998, my lord, not 88, my lord.
32/1988. In this on top you say conviction just and so passed on 21/12/2018. Next is Jahan, then it's additional he prays for how much time?
1 week, sir.
1 week time to file objections. Praise allowed. List of the-
My lord, may I correct that case number, my lord, by hand, my lord?
It's corrected.
It's corrected.
Where?
My lord, there,
In the
in the
misapplication?
IA, my lord. It is 32 by, I have wrongly typed as 32 of 88, my lord. It should be 32 of 98. My lord. No, no, no.
7, hearing.
Seven, I think Mr. Prasad is appearing, B Prasad. In the morning, he actually applied for online, for doing it online. But then some personal difficulty arose, so he's on his way. He'll come back. So he has requested me to pass it over for some time for making a request to your lordship. So for some time. we can pass it.
A,
May it please your lordship. Lordship, this matter is voluminous and here lordship 21 witnesses are there, 9 DWs are there. And some legal issues are also there, lordship. So it won't be finished today, lordship. So I have some personal difficulty tomorrow. So I do not know whether in next week this bench will continue or not.
We are continuing.
Even I've gone through 5 witnesses. I was not well much yesterday. So I've gone
On
through 5.
request made by Ahmed, the amicus curiae.
Can it be on Tuesday, lordship, as first item? Then we can finish it.
I think we have fixed some matters on
Yes, it's
Tuesday,
part of it.
On Thursday, lordship, we present
on 25th.
as first item, lordship. Then we
No,
can.
one
finish it.
partnered matter is there, yesterday's matter.
Wait for some. We'll see.
Lord.
We can, you can pray for upgradation.
Lordship. Oblige, lordship.
Fourteen.
Who appears for the state?
14.
None appears for the appellant. MSB Boyan and addition. Assam is present. List the matter after 2 weeks.
Seventeen of supplementary list.
Next, please, lordship.
Lordship, before my learned friend starts, your lordship, I should not say, but in the corridor on the last occasion, he said like his clients are very poor. Otherwise, he would have offered some
No, not yet.
money to me, your lordship, that proposal is given. He should withdraw that, your lordship. That's
I have not
proper.
proposed. I have not proposed. Sorry, my lord, I have not proposed anything.
I don't understand what is happening.
I have not proposed anything, my lord. She's telling something. He could not understand.
She will just-
Lordship,
she will just say it from the blue.
She could not understand. I told
She
something
has
not
been-
like this.
She has been practicing before us. for
from
how
last
many years?
24, 25.
So much sorry for that, my lord. I'm asking.
Lordship, I should not say, but he had on the last 20 years back, Lordship, one of his cases were of Lordship transferred to Bar Council because of
This also we are thinking of sending it like that.
But I'm sorry, my lord, for that, my lord. Excuse me, my lord.
We are adjourning this matter.
My lord,
You are adjourning this matter.
kindly excuse me, my lord.
You get a date fix convenient to you, we'll hear you on the other day, not today.
My lord, on kindly on Monday, my lord, on hearing, not
not
one.
Monday. After 1 week, take a date.
My lord.
Take a date after 1 week.
Yeah, my lord,
This type of behavior we don't appreciate. You take some cooling off period and come back. Then you can talk to the additional PP. After that, we'll proceed with the matter.
my lord, excuse me for that, my lord. What you said, I have not forgotten, my lord.
No, you should admit
I'm
it that you have
saying-
stated
I'm-
knowingly, unknowingly, have you said to me? Yes or no?
I have never paid you, never to the, please, I'm begging sorriness, no? But excuse me for that, my
Whatever
lord.
it is, we are adjourning this matter today. You take some cooling off period. come back after 1 week.
My
That
lord,
also after you make your apologies or you do whatever you feel like before the addition. We are not taking up this matter.
my lord, kindly your lordship fix up a date for,
That's why I'm saying take a date after 1 week, not Monday or Tuesday.
my lord, then next Monday, my lord. Next Monday, my lord.
Heard Mr. H.R. Khan, then the counsel for the appellant, also heard MSB Buyan, then the additional PP Assam. List this matter for hearing on 5th June. 5th of June.
Fifth of life.
No. This is a hearing matter, is it?
Yes.
Did it be on a hearing day? 6th June.
6th June.
I think you should have, by that time, you should have sorted things out.
Well, I'm very sorry already for
You
that,
should
my lord.
sort your things out. By not, there's no point in saying sorry before this court. You have to address the person whom you have offended.
7.
This case, once your lordship heard it, allegation by the daughter against her own father, mother. Some jurisdiction.
You are appearing or Jahan is appearing?
I am appearing. I'll be.
Some jurisdiction issue?
Yes, my lord. Some of the part in Jorhat and other Patasar Kursi. The IO has said he has not investigated the whatever has, but it's a continuous offense, my lord. 376.
Okay. That's right. I think you were there also, no? Huh? We heard it together. Yeah. Oh, where is Mr. Prasad?
He didn't reach yet.
We'll adjourn it for 1 week. None appears for the appellant. None, cancel it. Learned amicus curiae is present, is absent. MSB Buyan and additional PP appears on behalf of the state of Assam. List the matter after 1 week.
Just a minute. I didn't know that.